Our final panelist is Daniel Troy. Dan is the Senior Vice President and General Counsel at GlaxoSmithKline. He was previously a partner of the Life Sciences Practice and Appellate Litigation Group at Sidley Austin, where he regularly represented pharmaceutical and biotechnology companies before the Food and Drug Administration and other federal agencies. He is the former Chief Counsel of the Food and Drug Administration. Before serving as Chief Counsel, he was a partner at Wiley, Ryan, and Fielding here in D.C. He's argued more than a score of cases in federal and state courts of appeals and has had a successful argument in the Supreme Court of the United States. He's published widely. He is a graduate of the Cornell University School of Industrial and Labor Relations and has his law degree from Columbia Law School. And from 1983 to 1984, Mr. Troy clerked for Circuit Judge Robert Bork of the United States Court of Appeals for the D.C. Circuit. Mr. Troy.
Thank you. Well, thank you. It is an honor to be here back at the Federal Society. It's an honor to be on the panel with such deep thinkers who think such deep thoughts. I'm now just a practical lawyer trying to muddle through deciding what cases to fight and what cases to settle. So I want to be very clear. I'm speaking on my own behalf, not on behalf of GlaxoSmithKline. And I want to basically make just a few comments and then throw open a couple of hypotheticals. Since I've got free expertise here, I really want to take advantage of it. And let me be very clear, my expertise is in the pharmaceutical sector, so I'm going to be approaching preemption particularly from that perspective. And unfortunately, I guess the title of the panel, the future of federal preemption, at least in my world, I'm not sure it has very much, but some people often ask what my thoughts are on Wyeth versus Levine. I view it, at least particularly from now where I sit, as a very much kind of a missed opportunity for the pharmaceutical sector, in the sense that before the debate about preemption was not a tool that the sector really had to fight off product liability. We relied on causation, wide variety of other arguments. And I'm not sure we're completely back to where we were from the start, in fact, and I think Catherine's ending remarks are very hopeful to me. So I think there's maybe a little bit more room, but obviously the opportunity that Wyeth versus Levine, or that the effort presented is one that did not come to fruition. So what I find myself, for any of you who are expecting fireworks here at the Federal Society, in incredible disagreement. I mean, who can disagree with Alan Morrison? There's not a word that he said that I disagree with. He made a plea for clarity with respect to Congress. Well, amen to that. I also agree with Catherine that I wouldn't hold my breath waiting for that. I completely agree with Alan that the kind of anti-preemption urge in Congress has gone way too far. I agree that I'd like to see this delegated to the agencies. I do think that they should exercise caution and should not necessarily preempt unless there is significant interference by the state regime with their decisions. I am delighted to hear, and wish it were the law, that companies have a right to say, don't make us put our foot both on the accelerator and the brake at the same time, because we feel as if we are asked to do that all the time. I'm delighted by the call for a fresh start, although, again, I'm not holding my breath about that. I agree almost entirely with everything that Catherine said. I think that the presumption against preemption is deployed completely haphazardly and is cited really as a post hoc justification rather than as an analytic framework. And normatively, I agree that we shouldn't have one. I mean, it doesn't really make any sense if you have federal agencies and you have very invasive federal regimes like the Food and Drug Administration, where you cannot test the drug, sell the drug, or say anything about the drug without getting the agency's approval. Why we should have duplicative state regulation through the tort system is always been a mystery to me, and why you should have a presumption against preemption if you have the Supremacy Clause and if you have Congress exercising power in that arena has always been a mystery to me. And Dr. Greve has a fabulous analysis that I won't even hope to repeat, but I'll invite him to share about how you end up with basically duplicative regulation rather than one regime or the other. Catherine and I have even agreed that agencies should get Skidmore, not Chevron deference on these issues. I do think that courts should take seriously the regulatory review that the agencies have done, and not duplicate what state tort law, and not allow duplicative of state law. And I'm, again, delighted to hear that she thinks that Wyeth does leave open a variety of these preemption questions, especially whether or not state tort law is duplicating the federal regime. And I do think that there's still some room, and the fact that the court asked for the SG's views in the vaccine injury compensation case, which I'll come to in a moment, is a hope to me that at least there is still some room for preemption in what I'll call my space, or the pharmaceutical space. And the last point, and I've always thought this, is that the rational approach, which is not to say that Congress is going to adopt it in my lifetime, it would be to have some kind of alternative injury compensation fund. Why? I mean, we have this in vaccines. We'll talk about that in a second. But when the FDA puts a product on the market, it knows to a virtual certainty that there are certain people who are going to be harmed by that product through no fault of theirs or ours. So let's take statins. GSK does not market one, so I'm not marketing anything. When FDA approves statins, which according to Bob Temple, the architect of the new drug approval regime at FDA, the most remarkable public health advance in the United States, or indeed in the public health arena over the last generation or so. If you're not on a statin, you should talk to your doctor about being one. Again, we don't market one. That's what Bob Temple says. I'm not a doctor. I don't play one on TV. But FDA knew that a certain number of people would get a pretty debilitating and potentially almost fatal condition called rhabdomyolysis. Terrible, terrible condition. The number of people who would get that would be in the scores. The number of people who would be benefiting from statins is in the tens of millions. So the question is it fair for those 50 people who bear that cost, that burden, that injury, through no fault of anybody's? It's just a natural consequence of the product for them to have to bear those injuries for the benefit of the tens of millions of people. I guess I would argue, no, you can really see why, as a public policy matter, they would be entitled to some measure of compensation, or at least their health care costs, we'll leave aside the health care reform debate, should be covered. Instead, what we do is we rely on the lottery called the tort system, which does not operate in a fair or science-based manner.